All right. Hello, everyone. Good afternoon and good morning to those not on the East Coast. I'm Trent Taylor, and I am here with some of my colleagues at McGuireWoods, and we're super excited to be doing another one of these webinars, and we're so happy that y'all decided to join us. As many of you know, we try to do these every few months to update our clients and friends about what is happening out there in the labeling world. And the last one we did was Valentine's Day, and it was a very different world then. But the one thing that really hasn't changed is that our friends in the plaintiff's bar continue to file new lawsuits on labeling. And our goal here today is to tell you about some of the recent trends, decisions, and new lawsuits that you may find of interest. And hopefully we'll have a little bit of fun doing that. So let me first of all just introduce our esteemed panel today. You have myself and Jenny Price here in Richmond, Virginia. You have Bethany in Los Angeles. You have Ben in Charlottesville and Royce in Chicago. So we cover the entire country. And here is a roadmap about what we intend to cover today. I'm going to start with a few trends that I see out there and sort of set the table. Then I'll turn it over to Royce to talk about recent regulatory developments. Royce will turn it over to Ben to talk about food and beverage labeling. Ben will turn it over to Jenny to talk about product labeling developments, and then Jenny will turn it over to Bethany for Prop 65 developments. And as always, you should feel free, if you have any questions at all, to submit them to us in the Q&A button at the bottom of your screen. And if for some reason you don't think of a question right now, but you think of one later, you should feel free to email us or call us at any time. One quick plug, which I typically do at the beginning of these, is that we have a monthly newsletter on labeling trends that really covers all the developments out there, both in terms of regulatory as well as lawsuits, litigation. If you have any interest in that, there's a nominal charge for it, but if you have any interest in that, let us know. And then we also have a labeling and regulatory emergency hotline and dedicated email address for emergency inquiries. And of course, we love, as you can hopefully tell, talking about the litigation, the regulatory development related to labeling claims. And if you ever have any interest or just want to basically talk about, a recent decision you saw or something like that, you should always feel free to email us or call us, and we love talking about it. And lots of times, we won't even sort of charge you for that kind of thing. We're just enthusiastic about covering these things. So just keep that in mind. So let me start with some trends that I see. And we have a little bit of a summer theme going here, so I'll start with one of the all-time great summer movies, Jaws. And one of the things that we have seen in the last few months is an uptick in lawsuits against environmentally friendly claims. And so in particular, non-toxic is a claim that has been targeted in at least 4 lawsuits in the last month. And that's something that I know we've mentioned in past webinars, to be careful about environmentally friendly claims like non-toxic, because we really see it as the next generation of food labeling class actions, and we're starting to really see that snowball. And this is a few examples. This is outside the food realm, but and relates to the non-food products, but we have seen similar claims involving food, especially where there's environmentally friendly, or sometimes it may relate to the packaging, that the packaging is compostable or that kind of thing. And these are big targets. And what we've seen and what we have on the screen here, and you can see these are very recent class actions that have been filed, both in California as well as New York. And there's 2 groups of plaintiffs' counsel that have been filing these. One is based on the East Coast, and those plaintiffs' counsel, they're the ones behind the vanilla suits, and they filed scores and scores of vanilla suits that Ben's going to talk about a little bit later in our presentation. But the fact that they've gotten into this game for non-toxic means that there's likely going to be a lot more of these lawsuits. And so I guess what I would say on this is, if you have these types of claims on your products, now is the time to review them and assess what their risk level is, because we expect a lot more of these lawsuits to be filed. All right, trend number 2, pesticide and glyphosate cases, which is somewhat related to what I just talked about. And the good news about these suits is that there have been 2 very significant decisions that have come out in the last month in the 11th and 2nd Circuits that have affirmed the dismissal of these suits. And this is essentially the type of suit where you have a plaintiff claiming that there's trace levels of glyphosate or other pesticides in the food, and therefore the label was deceptive if it called it natural or that kind of thing. And these lawsuits have not really gotten a lot of legs yet. There have been a number of district court decisions that have dismissed these at the motion to dismiss stage, and now we have 2 courts of appeals who've said no, these should not go forward. So that may mean that these suits are going to slow down. You'll see on this page that there is another one last week. Another court dismissed a similar suit involving a 100% clean label on bread and bagels, and they dismissed that suit against Panera, and the claim there was that there was glyphosate. But it's not completely dead. You'll see the last suit was a class certification was granted in a pure honey suit, and I think Ben's going to talk about that one in a little more detail later. So it's not completely dead. Maybe expect a tweak or 2 to the theory for plaintiffs, and they may try again, and I think it's important to stay tuned on this. But certainly if you have a case along these lines in the 2nd or 11th Circuit, then you should be feeling good right now. COVID-19 litigation. I don't want to talk very long on this because I know a ton has been written about it, and you could do an entire day seminar about it. Just want to note that plaintiffs' counsel have been very busy filing these lawsuits. And 2 things I'll briefly say about this area, and I know Jenny's going to talk a little bit more about some of this a little bit later, but there's a strong temptation for some to try to market certain products as antiviral or effective against COVID-19 or effective against coronaviruses generally, or even use a term like FDA approved right now. But you get on really shaky ground if you do that, and so it's most of the time best to resist that temptation. And then the second thing I'll mention is price gouging. There have been a number of class actions filed in the price gouging realm, and we've written a number of alerts about this. We have a 50-state survey of price gouging laws, and this is an area to watch. A lot of these class actions have been filed against platforms hosting third parties like eBay and Amazon, but some have been against grocery store chains. So something else to keep in mind, because we expect to see a lot more of that. Trend number 4, pet food. And I have to confess that one of the reasons I wanted to mention this is because of the picture I have here, because I just think that's funny and cute. But there's a larger point as well. So there's been 2 cases filed in Florida over the last 2 months related to pet CBD products. But I wanted to tie this into a larger trend because there have been a persistent number of labeling class actions filed against pet food manufacturers. There's another one, recent one related to a grain-free claim, another one related to prescription dog food. And I think that's because there's such a huge market for pet food out there, and I think we're going to continue to see pet food as a target for labeling class actions. Cosmetics, I wanted to briefly mention. There have been 2 recent cases that have been good developments for those in the industry. One involved a voluntary dismissal of a class action related to eye cream, and the other one is the Crutcher decision here, that where the 2nd Circuit affirmed a dismissal and found that those claims by the plaintiff were preempted. And that decision is notable not just for cosmetics or product labeling, but for food labeling as well. Because I think sometimes people forget about preemption or think it doesn't work very well, and that's true in certain places like maybe California, But if you have cases filed in the Second Circuit, even if it's food labeling, you should review this Crisher decision because it's significant. And even if you have cases elsewhere, always remember preemption, because I'm seeing an uptick in the number of courts that are latching on to preemption. So keep that in mind. And then the final thing that I'll mention before I turn it over to Royce is that there have been some good news. Ben's going to talk about this a little bit more, but courts are dismissing a lot of these labeling class actions. Some have called them puffery. CBD class actions are being delayed. And it just seems like courts seem to be tiring of some of these suits, and the courts are being rational and dismissing some of the weaker ones at the motion to dismiss level, which is obviously a welcome change and good news for those in the industry. But that's not always the case. We still are seeing some troubling results, like the last one here, where a healthy halo claim for sugar, a class was certified for 31 different cereals. So obviously there's good and bad, but we've seen more good results in the last few months than we typically see. So those are my preliminary thoughts, and with that, I will turn it over to Royce.
Thanks, Trent. So I'm Royce Dubonnet. I'm based in Chicago. My practice primarily focuses on regulatory law related to FDA, FTC, USDA, DEA, all the alphabet agencies, and I'm going to quickly go through some of the updates and trends that I've seen this summer with FDA, which I entitle FDA's Wild Summer Ride. Basically, we all know that FDA has been really, and the other alphabet agencies have been really preoccupied with COVID-19 and fighting COVID-19 and directing resources towards that. But that's not the whole story. There's been a lot going on as well. So some of the enforcement trends that I've seen this summer with FDA are FDA's shift from really enforcing COVID-19 claims on products such as, my CBD cures COVID-19, or this elixir or dietary supplement can prevent against COVID-19. Those are really danger zones in terms of FDA enforcement. The agency, along with the Federal Trade Commission, has been enforcing very heavily in that space. But we've recently seen FDA go back to going after other forms of CBD and CBD issues and delegating some of that enforcement responsibility to the Federal Trade Commission. Federal Trade Commission enforces under the Federal Trade Commissions Act. They're looking for fraudulent statements in the product. FDA will enforce under the Food, Drug, and Cosmetics Act for products that make basically impermissible claims, such as cures COVID-19, cures cancer. There still is CBD enforcement, but that's kind of been the handoff that I've seen. We know that FDA is actively still working on the CBD front. We have gotten no updates in terms of what FDA plans to do with CBD other than a trickle of some draft guidances, enforcement trends. But we know that there was something filed in the Office of Management Budget, which is the government agency basically looking at how does a regulation or regulatory action impact basically the economics or the business environment, in short. So we know FDA submitted a new guidance to them entitled CBD Clinical Research, which I think FDA is going to start thinking about how do we enforce a space that is quickly moving towards researching effective uses of cannabis, such as marijuana or hemp and hemp extract CBD. So that's forthcoming. The two major recalls that I've seen, which are kind of not earth-shattering, but they are in terms of the products that were recalled, but not in terms of why FDA did it. We saw in CBD injectable company issued a recall for that. They got a warning letter. Good rules of the road. Please don't it's probably not a good idea to put CBD in an injectable form and sell a syringe with it. The other enforcement trend we've seen is we've seen FDA enforce and ask, I don't think they asked for the recall, but they pretty much implied the company needed to do a recall. They sent a warning letter, and then the company issued a recall notice for CBD products that were laced with lead. And that was actually discovered, I think, by Florida's version of the FDA, basically the state agency enforcing food laws in Florida. It's interesting because most of the time FDA sends a warning letter and the products immediately get off the market. This time FDA has added, the added request. It's very rare for FDA to order a recall, but the request that the products be completely recalled as well. So when thinking about launching or selling a CBD product, be aware of the claims, but also be aware of the fact that you may have to do a recall if FDA does not like the claims on the product. On this point with FTC, we did see kind of the first time in the CBD space FTC get really aggressive and file a temporary restraining order against a company that was selling CBD products, very egregious claims, such as products cure cancer, products prevent COVID-19. It appears as though the defendant was literally ignoring FTC at every step of the journey, and FTC went to the length of getting a TRO. Just another tool that FTC has in its belt is to ask for a temporary restraining order to stop the sale of products that it believes are in violation of the Federal Trade Commissions Act. Continuing on our wild summer ride with FDA, it's important to realize that FDA has been, as I said earlier, focusing heavily on COVID-19 and has released a lot of guidance documents this summer for companies that manufacture food and beverages, ranging from the guidance about hand sanitizer, which we do advise a lot of clients on, to things such as if you've got bulk food and it's designed for restaurant sale, you don't have to worry about it. You can just relabel it and sell it to consumers. That's an abridged version of the guidance. And then there's been some other guidances such as ingredient swap. If you've suddenly found yourself running out of brown sugar in a product, you can swap it for another kind of sugar and you may not have to go back and update all your labels. But it's important to keep in mind that these are temporary policies. If you have followed one of these guidance documents and have followed FDA on some of these, relaxations of enforcement, FDA at some point in time will get rid of them and will say, okay, now you have to go back to being the way it was before COVID-19. The way things are looking, unfortunately, I don't think that day is going to come anytime soon, but it's important to just keep in your mind that if you've been following a guidance based on COVID-19 enforcement discretion, that FDA will revert back to the previous enforcement regime. Based on other parts of FDA industry and other instances in the past, I think FDA will give companies lead time to convert back to the way things were pre-COVID-19. I think they'll probably file a guidance or a notice of some sort saying, you have 3 months, 6 months to go back to the way it was once the national declaration of emergency is over. So just something to keep in mind, that note which products are being manufactured subject to a COVID-19 related guidance, and keep that in mind when FDA eventually reverts back. Another interesting trend we've seen this summer, and these are the plaintiffs, they're not actually EPA lawyers, although some of the people I worked at EPA with did look like them sometimes. But EPA has come out of hibernation essentially and has begun looking very closely at insecticides. So a lot of times people forget that EPA regulates insecticides, which share a strange space and accompanying FDA as well. So basic distinction is this: under FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act, EPA regulates essentially household products that make claims about killing germs and viruses, and the handoff to FDA is if those products make claims that can prevent the viruses in human beings. So the difference would be my Clorox wipes can wipe the table and kill the germs on the table, versus my Clorox wipes can wipe human skin and prevent cellulitis. It's kind of the handoff between EPA and FDA. EPA has relaxed some of the policies for notification. So if you're launching a new insecticide in this country, such as a new hydrogen peroxide solution or other solution to kill germs, it's important to realize that in the past you had to register that insecticide with EPA, basically file an application and show EPA the safety and risks associated with it. Another practice point is people forget that they also have to file at the state level. Every single state in this country has its own regime for filing insecticide products, and that includes everything from table sanitizers to our standard insecticides such as bug killers. But EPA has created this thing called the N list, which is a list of chemicals that EPA says, we're going to relax our notice requirement if you make a product out of the N list. And you can use these products on the N list. We believe that they have action against COVID-19, and you can go ahead and do that without a formal, it's kind of a relaxed registration process. EPA is actively enforcing. There are a lot of companies out there that are making products that are sold in store shelves or elsewhere in this country that are making claims about being able to stop COVID-19, and my colleagues will talk more about it on the litigation side. But it's the first time that I've seen EPA really start going after insecticide-type products, and they sent a letter to Amazon and eBay saying get them off the online store. And for clients, I think it's important to realize that you might have bought a bulk order of X product that claims that it can fight COVID-19 or claims it can do X, Y, and Z. It's important to make sure that that product is registered, it's a real product, that the manufacturer is a real manufacturer and not someone that just came out of the woodwork, and that the chemicals in the product are on the N list, and that the products have been registered in the state where you're basically selling them or dispensing them or utilizing them, because there's just so much rampant fraud in this space with companies coming out of nowhere, suddenly making sanitization products for the house that are either not effective against COVID-19 or the company has done nothing to ensure that it is properly registered in this country to do that kind of business. Swapping real quick to hemp, climbing up the hemp stock, that's the cannabis plant from a botany book. We've seen a lot of states get really good with submitting plans, as well as the Native American tribes get really good with submitting plans to USDA for hemp. If you recall, there's two kinds of hemp programs. There's three, actually. There's illegal hemp, black market hemp, but we're not going to talk about that one. But there's 2014 and 2018 hemp. 2014 hemp means that it's grown under the 2014 Farm Bill, has to be a state plan, and the grow has to be associated with a land-grant university or academic institution. Illinois, where I live, has a 2014 plan in place. My last conversation with the Illinois regulators was they have no plan to immediately turn to a 2018 plan. But because Illinois has a 2014 plan in place, hemp can be lawfully grown in Illinois, but it can't be lawfully commercialized, sold across state lines. It's essentially the end of the road because it's a 2014 plan. I've never seen enforcement yet from USDA on that, but I think USDA is getting a little bit more interested in whether or not there's been a 2014 or 2018 plan put in place in the state. And the reason I say that is USDA released a comparison guide, basically a guide on their website, and you can email me and I'll give you the guide, that lays out the differences between 2014 and 2018 Farm Bill hemp. 2018 Farm Bill hemp, if it's grown in accordance with the state plan, is totally able to be commercialized, sold, and transported interstate. In 2018 hemp gets the protection of the federal government on preemption for transport across state lines. So if you're taking your hemp from, Ohio to Washington State, and you happen to cross Idaho, which hates everything hemp and cannabis, the Idaho State Police can't seize that hemp. They can if they want to, but they're probably not going to be able to keep it in detention because that hemp was grown under the 2018 Farm Bill. If it's 2014 Farm Bill hemp, they could probably seize it. So some states have come out and basically said, we don't care. We're going to continue with our 2014 plan because we just don't want to jump to 2018. Other states have moved towards the 2018 plan. So when considering buying agricultural raw hemp from the field or selling hemp products, as part of the due diligence that I've been talking to clients about is understand whether or not that grow or that extraction of the CBD has come from 2018 hemp. The 2018 plan lays out a very comprehensive testing regime to make sure that the THC levels in the product don't go above what is permissible, 0.3% delta 9 on a dry net basis, and to really start working that into the diligence process. Although there might be a product out there that's very interesting and looks really great to sell, it's important for a company selling that product to do the diligence and see, all right, is it made under 2018 plan? Was it properly tested? Was it properly converted? Was the entire step of the way done in accordance with what the state has said that extraction process needed to happen when it was taken from that field? And, I haven't seen enforcement on USDA on that part, but with a patchwork quilt of 2014, 2018, and states that are not in compliance at all with, USDA's position on the Farm Bill, it creates just a very eclectic field of whether or not you're getting a product from a state where it was lawfully made. And it's just a state spotting issue. The other thing is tribes and farmers that have USDA-issued permits can grow hemp within jurisdictions that may not allow hemp growth. Other interesting trend that I've seen recently this summer is the reemergence of cottage foods and the emergence of that, and just more and more states starting to relook at cottage food industries and allowing regular people to manufacture product. And I'm going to hand it off to Ben right now.
Thanks, Royce. This is Ben Abel. I'm an associate in the Charlottesville office, and I'm going to walk through pretty quickly some major trends we've seen in the food and beverage space in the past couple months. Like Trent said before, this stuff is either highlighted or will be highlighted in the labeling update that we put out for subscribers on a monthly basis. And it is a steal at any price. But the first of those is really, as Trent alluded to, that we continue to see refinement in a positive way for manufacturers of the reasonable consumer test. And relatively recently, we saw a decision in the Ben&Jerry's case in the District of Vermont regarding Happy Cow litigation. The very basic allegation was that Ben&Jerry's says that it has a Happy Cow program and that the cows are treated a certain way and raised a certain way. And the allegation was that not all of the milk used in the ice cream came from the Happy Cow program, and that was deceptive. And as you can see in the case being dismissed, and the quote that's here from the court and its decision, the court basically said a reasonable consumer can't focus on one part of the label, or in this case, the website and the information provided, and just single that out without any context. And while the court said, sure, you don't have to read every single thing that might exist about this, you can't isolate it. And so what the court said in dismissing that case was Ben&Jerry's basically never said all of its milk came from the Happy Cows, but the Happy Cow program was described on the website and described how if a producer wanted to be part of that program, they could be a part of it. And so that's really helpful for defendants that we've seen courts say you can't just look at labeling claims, website claims, any sort of marketing claims in isolation without reasonable reference to all of the surrounding information around it. And similarly, we've seen that in the couple of white baking chips cases that have been dismissed. Both were pending in the Northern District of California. Those are the chips that you would use for baking cookies or something like that. I will not call them chocolate chips because they The whole point of the litigation was whether or not they were made out of white chocolate or not. In those cases, the labels said, these are white baking chips, and plaintiffs basically said, you're trying to trade on the fact that otherwise you have chocolate chips, dark chocolate chips. They are stocked on the shelves near the chocolate chips, and basically by using the word white, even though the labels never specifically say white chocolate on them, you're tricking customers into thinking that they are white chocolate. In those cases, two of which at least have been dismissed by the court. And again, the court essentially saying a reasonable consumer looking at the label where there's nothing on it that says that they are white chocolate, that the ingredients list isn't otherwise incorrect in any way. These kind of outside factors when a reasonable consumer looks at the label aren't sufficient to sustain the litigation. But this trend hasn't been universal, and Trent mentioned the honey case that's been certified for class certification. This is a case alleging that 100% natural honey that allegedly contains trace amounts of glyphosate is deceptive because the allegation is anything with glyphosate in it can't be natural. And this is a claim that we've seen on the reasonable consumer test in other jurisdictions and other courts and other cases get dismissed as basically a reasonable consumer understands how the agriculture and producing process works. And they understand that insecticides and pesticides and herbicides are a part of that process, and trace amounts basically aren't concerning to the reasonable consumer. And at least one court out there has said, well, not so fast, and in fact is now certified classes. So we continue to see a growing a body of case law that we really like, but it still is case and judge specific. The next trend that we want to highlight are flavoring suits, for lack of a better term, continuing to be filed almost exclusively in the eastern and southern districts of New York, almost exclusively by two plaintiffs' attorneys that have kind of made this their pet project. The first of those are the vanilla flavoring suits. We're up to, we track all of those that have been filed. I think we're up to 70, 80 of those at this point. The basic allegation that vanilla products, this really started with vanilla ice cream, but has moved on to other vanilla products that are, the allegation is that if it says vanilla on the label, that it needs to be flavored solely with vanilla bean or vanilla extract, to the extent that it's flavored with anything differently, that's deceptive for a consumer. And the allegation is that when a consumer sees vanilla on the label, they take that to mean that's an ingredient claim and not just a flavor claim. Those of us who are defending these cases and our clients obviously see it a bit differently, but we still see those cases rolling in on a monthly basis, and those same attorneys have now expanded that past just the vanilla cases, and you'll see the list here of new allegations following the exact same template. Lemon cookies, you show a slice of lemon or a lemon wedge on the label, but your cookie isn't actually flavored with lemon juice or lemon zest. Cheddar and sour cream chips, you show a block of cheddar and a bowl of sour cream on the chip label, but your flavoring doesn't come only from cheddar, cheese, and sour cream. Chocolate dipped ice cream, same thing. Seltzer waters. I'll call out the Smokehouse Almonds case here at the bottom, because you'll see that's filed in the Northern District of California. Kind of oddly, for what we typically see in this space, we have not seen a ton of copycat litigation in California and other jurisdictions. Whether that speaks to whether the larger plaintiffs' bar thinks these are viable claims or not is a different question, but we just have not seen a lot of these copycat claims or copycat cases filed in other jurisdictions. In fact, I think yesterday or earlier this week, one of the few vanilla cases filed in California was dismissed by the California court. So this has not gotten traction elsewhere. But to the extent that you are on the receiving end of one of these flavoring cases filed by these plaintiffs in New York, either a vanilla case or one of these new kind of expansion of the flavoring claim, the first thing you should do is call McGuireWoods, and we have a lot of experience dealing with these cases, and we'd be happy to talk with you and help you out. But the second thing is that there is some helpful case law involving these attorneys in New York federal court, and I've listed the Melendez case and SAR case, the first dealing with protein bars and the second dealing with butter. Neither of these cases are flavoring cases, so I want to make that clear, but they are cases that judges have dismissed claims brought by these attorneys that follow the exact same template as brought by these attorneys that they're using in the flavoring cases, and they are obviously recent cases from New York courts. And so they provide a very good roadmap for how you want to think about responding to these types of cases brought by these types of attorneys in this specific type of way, even though they, again, aren't specifically labeled or aren't specifically flavoring cases. They'll give you a really good roadmap for how to think about ways that you want to respond. And we've used them in the flavoring cases we've been a part of as kind of a way to think about these claims. So these don't show any sign of stopping, and given the procedural irregularities and specifics of the southern and eastern districts of New York, we have not really seen a ton on the merits, a really good motion to dismiss sustained or granted on the vanilla flavoring cases in New York. And finally, I want to talk about positive developments in the food service and retail space. I know we've got some people who are in retail and food service that are attending, and a series of really good decisions. The Second Circuit affirmed the dismissal of an Angus breakfast sandwich suit. Basically said that the marketing materials showed a Angus burger patty, and that the allegation that the plaintiff was expecting pure Angus steak, a piece of steak on her breakfast sandwich, was not what a reasonable consumer would think. And then also, by the way, hamburger steak is a term that exists. P.F. Chang's had an imitation crab suit dismissed. And the court basically said a reasonable consumer looking at crab spelled with a K, crabnik spelled with a K on the menu, would understand that is different than crab with a C on the menu. And then also a reasonable consumer understands that when I order a low-cost California roll in a P.F. Chang's, a reasonable consumer understands that is a product that comes with imitation crab as opposed to real crab meat. Taco Bell, $5 chalupa meal. The menu board said what the price was. The receipt said what the price was, and so a reasonable consumer wouldn't be confused as to what the price of the meal would be, regardless of what some other advertising should actually said. So, with that, I'll turn it over to I believe Ginny is the next one up, and thanks so much for your time.
Thanks, Ben. So I will talk about some product labeling. These are a couple pictures of the different products that are currently facing lawsuits. But first, I want to update the group on two cases that we've talked about in the past. The first is the youth baseball bat case, which is a purported California class action dealing with youth bats that were actually alleged to be 2 to 3 ounces heavier than their advertised weight. The last time that I updated you guys on this case, Judge Wu had dismissed the breach of implied warranty and unjust enrichment claims, but had allowed the California false advertising and competition claims to move forward. And that is now under consideration for class certification. So we will continue to watch that case, but that's an update that it is now in the class certification stage, and it'll be interesting to see how Judge Wu handles that. The next case is the CVS aloe vera case that I had updated you guys that the Northern District of Illinois had granted summary judgment in favor of the defendants due to lack of sufficient evidence that the aloe products at issue do not relieve sunburn as the companies claim. The plaintiffs appealed that decision, and the Seventh Circuit affirmed the district court's judgment and agreed with the district court that consumers lacked the scientific evidence to support their claims that the aloe vera products did not work. So that's a bit of good news on the product labeling front. The next update is on the Purell cases. Purell's parent company is Gojo Industries, and they had been hit with an FDA warning letter regarding their healthcare advanced hand sanitizer. They were advertising it as effective in fighting Ebola, norovirus, and the flu. Interestingly, it was marketing that was actually within their frequently asked questions on their website that drew the ire of the FDA on this. It wasn't something that was, specifically on their product labeling, the product label. But the FDA said that in its warning letter that it was not aware of any adequate or well-controlled studies demonstrating that the healthcare advanced hand sanitizer killed or decreased the number of bacteria or viruses on the skin. And following that FDA letter, I discussed that plaintiffs had filed class actions in New York, Ohio, and California. And this was all pre-COVID territory. This was back in February. So just on the cusp of COVID sort of taking over the world, but those cases are still, moving forward. Gojo has recently moved the transfer of the nationwide class action that's filed in New York to the Northern District of Ohio, but the New York court has not ruled on that motion. So we will continue to follow those. But in the wake of COVID, there has been a flurry of hand sanitizer class actions. So Gojo was sort of the first wave, pre-COVID wave that was in reaction to the FDA warning letter. And since that time, since COVID-19 and since hand sanitizer has become such a hot consumer item, there has been just a number of class actions that have been filed. The first of which is the Germex parent company, Vijon Inc., was sued in the Southern District of California for a class action involving claims specifically regarding COVID-19. And then other class actions have quickly followed against manufacturers, again, against Purell and Target brand hand sanitizer, which they're alleging have deceptive marketing related to the effectiveness of the hand sanitizer products. A lot of what we talk about with advising manufacturers or distributors or relabelers with hand sanitizer is really just staying away from making claims regarding specific pathogen effectiveness, especially with COVID-19 being on everybody's mind. Folks are really trying to lean on trying to make claims about the effectiveness of a product against COVID-19. And from the FDA perspective, that's a no-no, especially with something like hand sanitizer that is treated and considered an over-the-counter drug by FDA. So just be aware of that, and that, if companies are looking to get into the hand sanitizer business, that there has to be an FDA step in there because it is regulated by FDA, and that plaintiffs' attorneys are all over hand sanitizers, and it is a big area in class actions and across the country right now. So some other products that have come under fire, I'm going to talk about three separate cases that deal with different types of products. And Trent alluded to this as one of the trends in his presentation, but Amazon has been sued in the Northern District of California It's a class action seeking a state of California class. Various causes of action have been brought, essentially alleging that the disposable plates marketed by Amazon as not only disposable but also compostable actually contain PFAS, which they allege is very difficult to break down in the environment and contaminates the environment, and thus is actually not compostable. And in addition, the PFAS are also allegedly linked to health risks such as thyroid and immune system changes. So this is in the very infancy of its lawsuit. They've not, Amazon has not responded to the lawsuit, but this is one that we will keep on our radar to watch. The next is Johnson & Johnson was sued over its rapid release gel caps. The consumers that filed this in the District of New Jersey are seeking a class action alleging that Johnson & Johnson raised its price on Tylenol for the rapid release gel caps because they claimed that it was fast working pain relief, rapid speed, release medicine fast for fast pain relief, that it had laser drilled holes that allowed the release of medicine for fast pain relief compared to, you know, its regular Tylenol. So essentially they're saying that they were able to increase the price by making these claims that it was a faster working product than the regular Tylenol. Johnson & Johnson filed a motion to dismiss, which the court granted in part and denied in part. I think the most sort of telling part of the opinion was that all of the claims that I just read off to you about how fast working pain relief, rapid speed, et cetera, Johnson & Johnson was trying to classify that as puffery. And the District of New Jersey said, no, we're going to allow the motion, we're going to deny the motion to dismiss on the puffery grounds because we don't believe that this is puffery. So the consumer protection claims survived motion to dismiss. The Magnuson-Moss claims and the warranty claims, Johnson & Johnson won summary judgment on. As for the Magnuson-Moss, the District of New Jersey held that the Magnuson-Moss Act was not applicable to products that are regulated by the FDCA. And then on the warranty claims, there were some Song-Beverly claims made under California law that specifically carves out consumables not being actionable under the Song-Beverly Act. And then as far as a breach of express warranty, they didn't identify an actual express warranty that was made, or for the implied warranty, they could not, the plaintiffs, the court held that the plaintiffs could not identify how the rapid release gel caps were not fit for their ordinary purpose. So the warranty claims were all dismissed. The unjust enrichment claims survived the motion to dismiss, but the declaratory relief on was granted dismissal on that claim. So Johnson & Johnson didn't get fully out of the case, and we'll continue to watch this case. But I did want to highlight that the District of New Jersey really took a hard look at it at the motion to dismiss stage, and at least on the puffery actions, on the puffery arguments, did not find that Johnson & Johnson made, that the statements rose above mere puffery. Finally, the last case I want to talk about is the Owlette Smart Sock, and they won dismissal of their case for now in Utah. Two moms alleged that the Smart Sock, which I have very young children, so I was aware of this product, but for those of you that don't know, the Owlette Smart Sock is basically a pulse ox that monitors oxygen levels and heart rates of a baby. And it's essentially a sock that you put on that has a little pulse ox in it. And the two moms interestingly, had different allegations about what was wrong with the owlet stock. One said that she continuously got false alarms or alerts from the owlet stock, that she would go in there thinking that, her baby's either oxygen level or heart rate was too low and she was fine. And the other mom had the opposite issue, which was that her baby's oxygen level was too low and she wasn't getting any alerts. They did not identify a specific defect with the owlet stock. They just claimed that they were told, this was a vital sign product, and that their baby would be monitored, and that was false because they were having issues either with false alarms or with not alerting. But they didn't actually have any sort of defect that they alleged. And the court granted Owlet's motion to dismiss in total on all of the claims. So they had a claim for warranty and unjust enrichment, which was dismissed for failing to plausibly plead that the Smart Stock's alleged shortcomings arose from a defect. And then they also had consumer legal remedy claim under California law and an unfair competition law under California law claim that the court found the plaintiffs failed to allege that the defendant should have disclosed what a reasonable consumer would have expected from a pulse oximeter, and whether those were and whether there was a difference between the two. Plaintiffs thus failed to plausibly allege material omissions, and their CLRA and UCL claims should be dismissed. Owlet tried to push the envelope a little bit by saying that plaintiffs should not get leave to amend, but that was the only part that the court denied. So it'll be interesting to see if this case comes back, and we'll continue to monitor it, but it was a good outcome for Owlet on that case in Utah. And with that, I will turn it over to Bethany.
Hi, everyone. Bethany Lukic in our LA offices. I wanted to end today with a little bit of a wrap-up discussion about Prop 65, which is, of course, California's statute that requires warnings to consumers at or before the point of sale of certain listed chemicals determined to cause cancer or reproductive harm. The first topic that I'm going to talk about is some amendments to the regulations, and the amendments deal primarily with how to give notice to a downstream supplier of the obligation to warn. So under the Act, you can either put an on-product warning label, or it used to be that you had to tell the retail seller that they needed to put some sort of warning out at or before the point of sale. So some sort of tag or product shelf warning. The amendment changed that now you can just warn the seller below you. So the seller that you are immediately transferring the product to, so long as that intermediary is subject to the Act and would have a separate obligation to warn under the Act. The amendments also clarify that this notice that is provided must be renewed annually, and there must be some sort of confirmation of receipt. And so I put this picture here of a posted notice. That's likely insufficient, but if you have, some sort of certified mail, if you have some sort of signature receipt, etc., all of those were given as examples by Awayha in the statement of reasons with the amendments as sufficient. The other sort of hotly debated changes about how and when a retail seller must provide notice. And there are many circumstances that are listed in subsection E5 that I've cited there. But one of the subsections is basically if there's no other way that a retail seller is notified and they haven't added the allegedly harmful ingredient in itself, then they may still have an obligation to label the product and give the warning. And the WAHA clarified what this actual knowledge means. And they say basically if you receive information from a reliable source that allows the retail seller to sufficiently identify the specific product or products that could cause the consumer product exposure. And I think the scary thing about this is that I believe that the plaintiff's bar will basically say, state of the industry, some study that's published publicly that a retail seller could have actual knowledge might trigger this independent obligation of a retailer to label versus the actual manufacturer or distributor or somebody further up the chain. Next, I want to talk about some action in the acrylamide arena. Acrylamide is basically formed when you cook certain food products at high heat. And so it can often be sort of a byproduct of the cooking process or, even grilling process, but it includes a whole bunch of different foods. And acrylamide was initially listed as a chemical associated with some industrial settings and not with food. There have been over 580 different 60-day notices by private enforcers dealing with acrylamide and food products. And there have been virtually none of those have been litigated the whole way through, but it is a constant threat by the private enforcers. And so the California Chamber of Commerce sued the Attorney General out here in October of last year, seeking declaratory judgment against enforcing listing acrylamide as a cancer-causing agent on food products because its members were continuously being dinged. There was one party that was allowed to intervene, CERT. They were a private enforcer against Starbucks in acrylamide dealing with roasting coffee beans in a case that started in 2010 that is very complicated but up in the appeals process right now. And so they joined and also were a party to the case. The initial motion to dismiss was granted on some procedural grounds, basically under the Declaratory Judgment Act. An amended complaint was filed this past March. A hearing was heard a couple weeks ago, and it's currently being heard by or under advisement by the court, pending in the Eastern District of California. So we'll be watching that to see. There are some really interesting procedural issues going on with, whether a group like the California Chamber of Commerce has the standing to move forward and seek this type of injunction against the Attorney General and private enforcers. And then I'm going to end with a little bit of dessert for the day, a little discussion on chocolate. And this is just, sometimes we all see these 60-day notices being filed with the Attorney General. And a lot of times the Attorney General leaves enforcement up to the private bar. And here is an instance where As You Sow, which is a very active consumer group out here, tried to, enforce some lead and cadmium levels that they claimed were in various different 22 different chocolate products, and the Attorney General did step in and basically say, what you filed isn't sufficient. There isn't sufficient evidence to show these levels of lead or cadmium in the product, or that the levels that might exist are harmful. So the evidence basically presented was insufficient, and they told As You Sow that their cases lacked merits. There was also a recent rejection of listing processed meats that came out by the Attorney General back in March as well. Just basically, there was too insufficient scientific evidence and too insufficient, there was too vague of too many different processes to process meat in order to list processed meat as something that needs warning under Prop 65. So I recognize that we're a minute or two over our time today. I'm going to turn it back over to Trent.
Yep. Thank you so much to all of our presenters, and thank you all for attending today. Really appreciate it. We'll have another one of these in the next few months. In the meantime, if you have any questions or just want to talk about any of this, feel free to contact us. Thanks so much. Bye.